There are more than 100 ways of coming to Canada. Express entry is understood abroad as a system of immigration processing. This is the management system which processes these applications. This is computer based. You or your lawyer can do everything on computer without any paper application. So all the federal skilled workers who are eligible, they may be able to apply for Canadian immigration under express entry system. The common pitfalls of the federal skilled workers applications. Now, there are so many reasons. I could not summarize all the reasons here because there are, I think they may run in dozens. One, the people are not able to determine their minimum eligibility. So what happens, they have not calculated it well, and based on some misunderstanding, because you're not submitting a lot of evidence at this stage. You make a calculation, you try to submit your 67 points to your EOI based on minimum eligibility points, and later on you realize that the calculation was not correct. Naturally, the process won't go forward from there. Then when you're submitting an EOI, I have commonly seen that people look at the knock codes, and then when they are matching or when they're picking up the code which matches their experience very close, they add in that, and they, without relying, just they look at the code, a couple of words used in the code, and then they when they are picking up the code, they feel that yeah, my job description or the work which I'm doing, it closely relates to that, while it is not closely related to any other errors in your expression of interest. Your application is bound to fail. So we have noticed that even in these applications at advanced stages, sometimes the immigration authorities, they call you for interview. This expression of interest, if the knock code is not correct, then they may call you for interview. And during that interview, they will have a very, very thorough discussion with you. And they would try to assess whether you have performed the duties which you are claiming in the knock code. So in last year, we had a client interviewed for 1.5 hours only based on that. That client was residing in a country where the consulate didn't exist, so he had to travel to another country, another consulate in another location, and he was interviewed only for the job description and the knock code, and then they finally determined that, look, you do not meet these knock code requirements, and your experience is not what you have suggested, an experience which meets the knock code requirements. So there were some mistakes committed by the visa officers in that particular interview, and they were not doing it professionally. There was an incorrect understanding. So we later on clarified that understanding through extra submissions, and then ultimately that client is today a Canadian permanent resident. But it happens. So these knock codes, job descriptions, you have to match them very closely in both the knock code as well as your job description. If there are errors in it, despite the fact that you've met all other elements, you may still not be able to immigrate to Canada or succeed in an application. Then there are incorrect understanding of comprehensive ranking system. People go on the online calculators, try to calculate it there, ask a friend or a family member who did it. They try to simulate their experience, and misunderstanding of the comprehensive ranking system is something which can also be a recipe to disaster. Now, these comprehensive ranking systems, they are managed through the ministerial instructions. When we are looking at the comprehensive ranking system and we are calculating these scores, we go to the ministerial instruction, those notices which are issued by the Minister of Immigration, and then they have set out all different scoring patterns in that, or what should be, how a person should be scored. So if there's an incorrect understanding of comprehensive ranking system, you may be under a misunderstanding that I have high enough score in the CRS and I could still I would be able to immigrate, but you may not be scoring that high in that. Then the burden in these applications is on the applicant to establish all their credentials. Like, establishing age is not a complex thing, like you provide your valid passport and other IDs and your age is established. But establishing your experience in a particular knock code, establishing that was a full-time experience and you were paid for that, and your company is able to vouch for that experience and certify that experience, that's very important, especially for the people who are not working in multinational or high-end corporations, because those people are the ones who are not working in an organized, not all of us are working in Unilever or Philip Morris or Racket and Keyser and other companies. Now, these people, those people who are working in smaller companies, local companies, in their own family businesses, they are looked at very closely, because there could be an element of misrepresentation there, or there could be an element of maneuvering there. So that's assumed or presumed maneuvering by the immigration officers. So you have to understand these requirements. Now the burden is on the officer. The officer would give you an opportunity in the application, and in rare cases in an interview, but it is the applicant who must establish all those credentials. If you somehow, based on misunderstanding or not pleading very diligently, you're not able to convince the officer, then naturally you have not met the burden of proof in that case, and the application may lead to refusal at some stage. Now, similarly, misunderstanding of settlement funds, we've already discussed. There are inadmissibility issues that we have touched upon them previously, and we could tell further that anybody who meets all the requirements or is the highest scoring candidate, if there are criminal inadmissibility, medical inadmissibility, inadmissibility based on misrepresentation, inadmissibility based on some other security grounds or human rights violations and other reasons, that person could still, despite having met all the elements in the Federal Skilled Worker Program application, may still not be able to qualify and could be refused to be immigrated or to be issued a permanent residence of Canada. So if there are some reasons, it's a good idea to talk to your lawyer, to explain everything to them, and then address those issues before you start with your application. Misrepresentation scenarios, I would just give you a couple of examples. Sometimes you are applying for a visitor visa to Canada, or you are coming on a study permit. You have submitted application to Canadian authorities for your previous education, your work experience, and other issues. Now, this application would remain in the database for a long period of time. Now, later on, you submitted or you were even refused an application. Later on, you applied for permanent residence based on the federal skilled workers category, and you submitted an information which was contrary or which was in conflict with the information you previously submitted in a previous application. Now, based on that, you may be slapped with, I'm sorry to use this word, with the misrepresentation ban. So if your application in the past carried an information which was in contradiction with your current application, you may be barred from entering Canada temporarily or permanently for a period of 5 years. So it's very important that you keep all the information consistent during this process. Now, we have seen there's a question in a few of you who might have applied for a temporary resident visa, or someone in their family has applied. They may be aware there's a question in those forms that have you ever been refused visa or entry into the US, into Canada or any other countries. So sometimes people just look at the application, and then if they have never been refused visa of Canada, they answer no, though they might have been refused a visa for Europe or UK or another country. So when the immigration has that information, has this means to verify that information, and they feel that you didn't correctly answer, we have seen cases slapped with the misrepresentation ban for a 5-year period. So unfortunately, even if that person has got enough of score, the CRS scores and eligibility factors and everything, if there's some misrepresentation involved even on such a minor issue, then one may not be able to come to Canada or even apply for permanent residence or any other kind of temporary residence.
If you wish us to help you in this, please contact my office. My contact details are displayed at the end of this video, and we would be very happy to help you in this matter. Thank you very much and have a wonderful day.